The whole thing in the future is going to be, we're going to sue these people and hope like hell they don't read the paperwork. Nowhere in that bill of sale does it show how Pagaya AI Debt Grantor Trust 2022-1 obtained the debt of my client. With this AI fintech debt creation, there's so many missing parts, and you can tell just from this, they left out the creditor. It's just not done. You always mention the creditor. Hey, Brian Parker here with another exciting video. Exciting for me. I'm gonna get back to breaking down a lawsuit, and you know, I've been making that, it's not a joke. There's the expression, you may not believe in AI, but AI believes in you. And I've done videos on AI debt collectors of an AI debt collection lawsuit. So let's take a look at that. I want you to remember this, especially at the end. For the want of a nail, a kingdom was lost. I say that to you to give you hope. As I take you along through this lawsuit that's against a new client that just came in, I'm gonna give you what the want of a nail, a kingdom was lost means. I'll just read it, but I know what it is. There is a domino effect with the loss of a single horseshoe nail results in a lost shoe, a lost horse, a lost rider in the battle, a lost battle, and finally the loss of an entire kingdom. For the want of a nail, a kingdom was lost. So that emphasizes how seemingly insignificant details can give you grave and unforeseen consequences for debt collectors. So let's take a look at that. So we're gonna revisit very briefly, at least the expression, our old friend, the linchpin of the lawsuit. So there's got a couple of videos up there on linchpin. Identify the linchpin, knock out the linchpin, boom, it all falls down. So this is the beginning of the AI collection lawsuit. And it's coming from an old friend, Fintech. So that's a huge source of debt and debt buying portfolios are the Fintech debts. So here is a complaint based on a Fintech AI lawsuit. Shazam. And that's your basic complaint. That's filed in Michigan. I show you all the paragraphs, but we're gonna focus on our linchpin, which surprisingly, I've never had this before. Number one is the linchpin, and number two, but usually it's buried in the middle of this thing. But let's take a look at the standing and chain of title issues here as we move towards finding out what that nail is that kills a kingdom. So let's go. If you take a look at the lawsuit at paragraph 1, it says the debtor entered into an agreement for an extension of credit with Pagaya AI Debt Grantor Trust 2022-1. How do we know it's AI? Hello, it's right in front of you. It's an AI trust setup, okay? They're making no bones about what's going on here. Everything now is based upon an AI platform. If it isn't in your life, it soon will be. You can't just say, well, I'm not gonna be part of AI. It's a part of you.
I don't like fighting fights that I can't win.
You don't think you could beat AI?
I don't think you can beat AI. I think you need to go with it. I think we need to look at how do we create business that works well with it and perform faster and progress as it progresses, because it's not gonna stop progress. It's just everybody got a different point of view on it, and they go, I hate this, we should cancel this, and then they be at home using AI. They'll be there saying, how would you do this a different way?
To ChatGPT.
Actually, ChatGPT. To do the same thing, they just did a different way just to hear it.
Yeah.
So instead of sticking your head in the sand, let's take them on. So the lawsuit at paragraph 2 says LVNV funding was assigned the debt by Exhibit 1, a bill of sale. There it is, the plaintiff is the assignee of the debt obligation with full rights to collection of the same. That statement alone is a bunch of BS, just a lawyerly way of saying things that are up for interpretation, but I digress. So let's take a look at the bill of sale, and here's where the fun begins. So Shazam, there's the bill of sale. Look at that. When I say look at that, first you'll see the body of the bill of sale, but you can see a number of those trusts. They're all trusts, and the list of the trusts involved in this debt is enormous, maybe 100, and I'm going to show you every single one in one page, but I cut out a couple of pages just because it's not worth it. Just take up your time because my point is going to be made for you. If you look at Exhibit 1, it's extraordinarily complex and listing dozens of financial institutions and a bunch of trusts with no clear chain of title, not an assignment in any of those. And remember, a bill of sale is not an assignment. An assignment flows through what's called the statute of frauds. Some states like Michigan have an actual codified statute that says this is what an assignment looks like, and there are case law upholding that, published cases. So Michigan's real good as far as saying 2 + 2 = 4. This case is filed in Michigan, and they've done a lot debt collectors have done a lot to try and wiggle their way through the law. And we've talked about how, if you recall, MRE 90211, submission of documents is a way of get stuff through without a witness. But they still have to prove standing to establish they own the document. Nowhere in that bill of sale does it show how Pagaya AI Debt Grantor Trust 2022-1 obtained the debt of my client. There's no specific name, no specific mention of my client's account number. And there has to be a signature and an authorized signing. That's specific to the actual, if you will, assignment statute in Michigan and hopefully in your state. So if there's no assignment agreements, no purchase agreements or documentation showing how Pagaya AI Debt Grantor Trust got something to LVNV funding, there's no case. That's the nail. But the bill of sale appears to be a bulk listing, obviously, and there's that mention of that. Let me just put up that paragraph 1 again. Shazam. Debtor entered into an agreement for an extension of credit with Pagaya AI Debt Grantor Trust 2022-1 or its predecessor in interest. If that ain't a bunch of nonsense, what is that? Nowhere in the complaint does it say who or whom, whatever that works, I still can't figure it out, is the predecessor in interest. You don't get away with that, which they will if you don't file an answer like the 8 to 9 to 10 of every lawsuit that's filed in America. We're trying our best to improve upon that. But if there's no identification of the predecessor in interest, and here, there's about 100 of them. If you look, and I'm going to show you them all collected real quick. So if you look at the bill of sale again, let's put it up there, Shazam. There is a mention of pursuant, and you know I love focusing on this, to the forward flow account purchase agreement. Yet, if everything is pursuant, meaning that bill of sale and all its progeny does not exist unless it flows through the forward flow agreement. Pursuant to something means nothing happens without the guidelines and the regulation of whatever it is pursuant to. And that forward flow agreement is even more important than the bill of sale if it's pursuant to it and it is not attached. And I'm going somewhere. Remember, when I'm pointing out all these things to you, you know what I'm doing? I'm writing your counter affidavit. In this case, I broke the case down that my client presented to me and created the counter affidavit doing exactly what I'm doing now. You take a look at the thing, you tear it apart and go, oh. I wasn't gonna do another LVNV funding one because I've been doing a lot lately, but this is so cool where I can see what I've been telling you, the AI debt collection of it all. Anyway. So this is cool too. So they add a transfer and assignment. Remember the one to the nail, a kingdom is lost. They add a transfer and assignment document to say, see, we own it. So here you go, Shazam. And that's a very common thing you find with Resurgent and especially LVNV funding. Look at all those trusts. I am not gonna waste my time or yours. Well, I wouldn't, I just read it and you'd know how long I took, but look at that. They're claiming all those trusts, maybe not, had a piece of the client's debt, their name, their debt, their account number is not in there. It's also, if you look at the top, without recourse, which means here, you take it. You can't sue us on this. You took a chance. But what the big point I am making to you is the one to the nail alert. One to the nail alert. The original creditor in this case, I'll show you what it is Blue Ridge Bank. How do we know that? Because we look at the paperwork that they attached. So they're telling you one thing, while at the same time attaching a paper that contradicts. And you've heard me talk about that because they just throw a bunch of stuff against the wall and hope some of it sticks and you don't notice. So here's the Truth in Lending Disclosure Act. That's a federal act under TILA, Truth in Lending Act, that requires every loan go through a statement of how much you're borrowing, how much is the interest rate, what are the payments, what will be the total amount of finance. Before you do the loan, you have to sign off on that. And you can see the lender is Blue Ridge Bank, NA. You didn't hear me say that until now. And then you'll see the actual loan agreement, Blue Ridge Bank, NA. It's one of those best egg loan agreement. That's another issue as far as ownership. But nowhere. Let me put up that transfer and assignment document again, Shazam. You want to take a little bit of time to read that and take a look at what I see, because I did take the time, and the words Blue Ridge Bank are not inside that transfer and assignment or anything. For some reason, they've done us a solid because it's an AI debt collection and have not mentioned the creditor anywhere, either in the complaint or in the actual documents that they say, see Exhibit 1, see Exhibit 2. So that's a beautiful, beautiful thing for you. Again, that's the one to the nail for not putting in the creditor, the actual creditor. We got it from this bank. They didn't even say in their lawsuit, which a lot of LVNV funding lawsuits do. They'll go, original creditor, like that last one I did with SoFi Bank, it'll say SoFi Bank to LVNV funding. At least they do that. It's still garbage. But this may sound funny. They're actually getting handcuffed. The more they depend on AI debt and these fintech loans, they get so sliced and diced, and now the introduction of the AI platform, I'll show you what that means in a second, they're really not getting anything to sue you. The whole thing in the future is gonna be, we're gonna sue these people and hope like hell they don't read the paperwork. You gotta read the paperwork, because with this AI fintech debt creation, there's so many missing parts, and you can tell just from this. They left out the creditor. It's just not done. You always mention the creditor. But you now have a securitization defense. Let me just show you what I did, and I don't use AI per se to write or create these things. But if I do depend on something, I want you to see it. So I Googled Pagaya AI Debt Grantor Trust, and this is what came up, Shazam. They talk about how it's a loan origination. So a loan originator is Blue Ridge Bank. They originate the debt, then they sell it to a trust who slices and dices and does whatever. Pagaya's AI platform helps its partners like banks and fintechs approve and originate consumer loans. Securitization, just like I said, these loans are sold to a trust, the grantor trust. So right there is a hint and a half that the creditor had it, it got sold to a trust. In this case, Pagaya AI Debt Grantor Trust. It doesn't take much to do what I did, which is Google and put it into either your answer or your counter affidavit, but it shows you the origination and then it goes to securitized trust. Pagaya AL Debt Grantor Trust 2022 is a trust. And there's no doubt, it actually says that. And then the asset-backed security, ABS, the trust finances the purchase of these loans by issuing different classes of notes. So the slicing and dicing is they take the originator, sells it to the trust, then they cut it up into classes. So let's say the trust buys a stack of really good loans, meaning 700 FICO score and above. So those will go into high class. There's little risk, so the notes will be sold to people that don't want a lot of risk. If there's a bunch of loans that were created with say 650 and lower FICO score, that's a higher risk. So that batch is put into a trust and sold with a riskier promise, but a real big payoff if the payments are made and they stay alive, they don't default. It's just normal transactions, securitized transactions. So then whatever payments are made by the borrower, you and me, to the creditor who we still think owns it, and they just become a servicer, those payments are sent to the trust, the creditor takes a piece, and then the trust disperses all the money from the payments to the different categories of notes. That's how it's worked. And I put up there how it works with those categorizations, Shazam, with the Google address, so you can see where I got that from. I just want to be clear. So with all this, you create the counter affidavit, the lifeblood, the blueprint of your case, your defense. Don't do anything else till you've done that. Now what do? You remember my video just recently? Let's put it up. Do I file an answer or do I file a motion to dismiss, seeking alternatively more documents? Do you remember what we're supposed to do? You are so smart. That's correct. You file that motion to dismiss and seek an order for more, what's called more definite statements. So the judge again is going to go, Parker, so I'll already give you a motion to dismiss, even though I've got overwhelming proof. But I'll make them give you the documents. And then under, at least Michigan, they have 14 days to get you those documents or they face a default. The reason why the judge is doing that is the reason why he should give me, and I sometimes do, get a motion to dismiss. So, and I've shown you orders where that's happened, but he's likely to cut the baby in half like a King Solomon and make them give me the documents. My point is, you want to come in with that motion rather than an answer, because the motion brings everything to the front. And guess what? The case gets settled. I showed you in that video where I said, do you do a motion to dismiss or an answer? And I showed you at the end where LVNV funding came in after the court ordered them more documents. Hey, we really need to settle this. So that's what'll happen. That's tactically a good move for you. I want you to like, love, and subscribe this video because it's the beginning of how you can see the wave of debt collection AI lawsuits are coming. This is an example. I'll attach a counter affidavit to this video, my show notes. But the show notes are pretty good. It'll tell you how to break it down and then go into the counter affidavit, depending on how you're sued. And then it's gonna be a little bit of work. I'll attach the motion to dismiss example so that you can use it as a template for your case. It'll help things, and then you'll be fine. So remember, Killdebt.com, I believe at the end of this week, beginning in November, we'll have 2.0. It is coming. I just did some tests of my own. I wanted to do like a loom and show myself using it because it's so cool. It really knocks my socks off. But we're in the glitch beta testing form and I broke it. And it's good so that when it heals, it's great for you. So as soon as I can, I'll do a loom or a video for you showing you how cool it is. You know what? It might be the first time you use it is on November because we're going down to the wire and we're trying to get it to you as soon as possible. It is really good. The developer's working overtime for you. But again, as a member, you automatically get the 2.0. Just be a member of Killdebt.com with Parker GPT. That's what I wanted to tell you. It enhances Parker GPT. It takes all your searches and archives them for you. Any videos you look at on the site, it bookmarks if you want it to, and puts it in your briefcase. So you have this briefcase that checks your searches, checking out case law. We got 1 million cases inside Killdebt.com. It'll save it for you, so you're not constantly having to go back. It'll save your chats. There's so much, I'm not doing it justice, but there's a ton of stuff it now does, and that's Killdebt.com with Parker GPT. And that is truly the AI superpowered defense that you're gonna need against the coming wave of AI debt lawsuits. Thank you very much, we'll get them. Bye.